I do.
All right, everybody be seated. Let the record reflect this is a proffer. The jury is outside the courtroom.
Ma'am, could you please state and spell your name for the record?
Christin Gonzalez, Christin Gonzalez.
Ms. Gonzalez, how are you presently employed?
I am a marital and family law attorney at Noby & Gonzalez here in Tallahassee.
And you're a named partner in that law firm?
I am.
And if I understand correctly, that law firm specializes in marital and family law?
That's correct.
Did you have an occasion to represent Denise Williams in a divorce action filed in Leon County against Brian Winchester?
I did.
Do you recall when you became involved in that case as Ms. Williams' attorney?
It was early spring of 2016.
As a marital and family law lawyer, are you familiar with the Florida rules of family law procedure?
I am.
Do those rules require a certain amount of financial documentation to be exchanged without court order?
Yes, they do.
What is that called?
It is called mandatory financial disclosure.
Is there also a requirement in a marital and family law case that the parties file a financial affidavit?
Yes, there is. That is part of the mandatory financial disclosure.
Do you know why that is?
It is so that all of the parties engaged in the divorce are able to accurately disclose the identification of assets, the valuation of assets, as well as liabilities and income information.
Does that also help you as an attorney determine what items may be marital versus non-marital?
Yes, it does.
Does the distinction of non-marital versus marital make an impact in a divorce?
It does.
Can you describe that, please?
What is subject to equitable distribution in a divorce case are the marital assets that are accumulated from the date of the marriage up through the date that the petition is filed. Any assets that are classified as non-marital are not subject to equitable distribution.
Is part of your role as the lawyer and as the professional in the case to help determine what may be marital, what may be non-marital?
Yes, it is.
As it relates specifically to the case involving Denise Williams, did you as her attorney make an investigation into her facts and circumstances?
Yes, I did.
Did you make an inquiry into the assets and liabilities that she had at the time of the divorce?
I did.
Did you also make an inquiry into the assets and liabilities that she had at the time of her marriage?
Yes.
And did you also have an opportunity to make an inquiry into any assets or liabilities that may have predated the marriage to Brian Winchester?
I did.
And in the course of your representation of Ms. Williams, did you cause to be prepared a family law financial affidavit on behalf of the wife?
I did.
Was that financial affidavit prepared by your law firm?
It was.
Was it prepared at your direction?
It was.
Was it prepared utilizing numbers that you felt comfortable with based on your own independent review and work?
Yes, it was.
Your Honor, may I approach?
You may.
Yeah, financial. May I approach with you, Your Honor?
You may.
Ma'am, I'm going to show you what is labeled as Defendant's Exhibit 3 and ask that you review that, please.
Okay.
What is that, ma'am?
This is wife's family law financial affidavit that was filed on April 3rd of 2017.
And what was the case number on that?
The case number is 2015 DR 2487.
Is that a court filing here in Leon County, Florida?
Yes, it is.
And the document that you're looking at, does it bear the certificate of the clerk of court showing that to be a certified copy?
Yes, it does.
Does that document reflect a certain amount of non-marital assets of Ms. Williams as of the effective date of the filing?
Yes, it does.
And can you briefly describe the nature of those assets, just what they were and approximate values?
Ms. Williams, as is reflected in this financial affidavit, had a Vanguard financial account with approximately just under $650,000. She owned a piece of real property prior to the marriage on Centennial Oak Circle. She had some retirement assets through the state of Florida, a deferred comp account valued at approximately $281,000, a lot on Miller Landing Road, a lot on Duck Cove Road, 2 Capital City Bank IRAs valued at cumulatively $53,000. Going back to those lots, those were each valued at approximately $200,000 each. She owned a Fidelity IRA valued at $40,000 and a Wells Fargo IRA valued at just over $2,000.
And based on your determination and review, let me back up. So for example, as it relates to the values that were assigned to the real property, is that something that your office would have been involved in calculating?
It is, yes.
And that's based on your experience and your knowledge as the family law attorney?
That's correct.
Do those assets, to the best of your understanding, total up to approximately $1.4 million total?
There's not a total reflected on the financial affidavit, but I believe that's correct.
Additionally, there were marital assets subject to distribution in this case, correct?
Correct.
And based on your review and valuation, what was the value of the marital estate before distribution or tax effect?
Before distribution or tax effect, I have reflected on the financial affidavit that the parties had $1,490,010 in marital assets.
That financial affidavit, a true, correct, accurate copy as you recall it being prepared?
Yes, it is.
And as you signed it?
I did.
Your Honor, it's been previously marked for identification purposes as Defendants Exhibit 3 into evidence.
State still object.
Yes, sir.
Thus sustain the objection.
No further questions, Your Honor. I do believe that the government would have an agreement as to the admissibility of Defendants Exhibit 2 by stipulation.
Right, and that was what I was trying to do earlier. Maybe it wasn't clear when I was saying, did you want to offer something now? Are you going to have her testify to that?
Not with the stipulation from the government, I don't think. So I would conclude my examination of Ms. Gonzalez, Your Honor.
That's the entirety of the proffer.
That is the entirety of the property.
Do you wish to cross on the proffer for any reason?
No, Your Honor.
All right, you can step down. Defense Exhibit 2, I'm sorry, is admitted. It's my understanding the state's agreeing to that.
Yes.
Okay.
Your Honor.
You may.
Your Honor, I'm going to get the clerk exhibit 3.
All right.
There's also
So are you going to have further testimony, Mr. Way?
I am not, Your Honor. I would do duty of inquiry.
Right. So you've made a determination that you don't believe that Ms. Williams is going to testify. Is that correct?
I have made that determination, Your Honor, in consultation with Ms. Williams and with co-counsel.
All right. Let's place her under oath, please.
You swear affirm testimony about to give in this case to be the truth, whole truth, and nothing but the truth, so help you God.
I'm afraid let's get the podium in the middle. State your name, please, ma'am.
Denise Williams.
And Ms. Williams, are you currently under the influence of any alcohol, drug, or medication?
No.
Ms. Williams, Mr. Way has indicated that you do not desire to testify. Is that correct?
Yes.
I'm not picking on you. I do this in every case where a defendant decides not to testify. The courts have decided that there are certain things that are the decision of a defendant. There are certain strategy decisions that are decisions of the attorney. One of the things the courts have decided is up to the defendant personally is whether to testify or not. You have good attorneys and you should consider their advice, but ultimately they're not the ones on trial. You're the one that's on trial, and only you can decide whether you should testify or not. Do you understand that?
Yes.
Has anybody told you that you could not testify?
No.
Has anybody pressured you into not testifying?
No.
You understand, if you wish, you can.
Yes.
I tell you that you have an absolute right to testify. You have an absolute right not to testify. Should you decide not to testify, I would instruct the jury that they're not to hold that against you. If you decide to testify, I will tell them that they should consider your testimony like any other witness. Do you understand that?
Yes.
Do you have any questions about your right to testify?
No.
You understand you can testify if you desire?
Yes.
Do you wish to testify?
No.
Any further inquiry, you think, Mr. White?
No, Your Honor.
All right, thank you.
Thank you.
So, with that, y'all will be prepared to rest the defense case.
Yes, Your Honor.
So how do y'all prefer to proceed time-wise?
Your Honor, the state is going to request that we, I don't have any rebuttal at this point. The state is going to request that we work on jury instructions throughout the rest of the day, and actually ask for a break for the remainder of the day, start ready to go with closing arguments tomorrow. I understand that we're at lunch hour now, and we could theoretically get it to them later this afternoon. I've been dealing with a head cold all week. We obviously were thinking we were going to closing arguments till Monday. We are obviously way ahead of schedule. I would request we do that tomorrow.
Okay, well, we need to let the defense rest in front of the jury, and we need to work on jury instructions. Does the defense have a posture of how you prefer to proceed?
I agree with Mr. Fuchs, Your Honor, that given the timing and nature of the consideration for the jury, it would be better to go to close tomorrow morning and submit the case, hopefully before lunch on Friday. I believe that both Mr. Fuchs and I and all the other attorneys have done our best to move as fast as we can, but sometimes we outkick the coverage. And I would admit, Your Honor, that I'm not 100% prepared to close today, but I would certainly be prepared tomorrow. I also recognize Mr. Fuchs is a little under the weather, Your Honor. Professional courtesy, I would have no objection to him asking for a pass tomorrow morning first close.
Yeah, and I don't have any preconceived idea. I assumed we were going to instruct and close tomorrow. I was just trying to work out a good schedule of getting the jury in, getting the 2 minutes more of what we need to do, and then getting them out of here without it being real awkward. I kind of hate that we have them coming back. But anyway, we'll do that. I think what we'll do, we'll break till 12:45. We'll have the jury in. They could probably be appropriate to offer your exhibit in front of the jury, State Defense Exhibit 2 that I've admitted, and then you can rest your case. Then I'll excuse them till tomorrow morning, and we can proceed on with our discussion of jury instructions. I need to read the case law that I've received on the request to amend the standard instructions. Hopefully I can get that done before 12:45. That would be our schedule if that works for everybody.
Yes, sir.
Okay, so let's be prepared then to discuss your instructions. All right?
Thank you.
I've got one. We have a transport list this afternoon that will be canceled.
Okay, the state's not going to have any rebuttal testimony.
That's
is that
correct.
right? Okay. All right, we'll be in recess till 12:45.
can,
So I'll go do it.